The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to this month's webinar on political affiliation discrimination in the workplace. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Leon Frierson, the Publications Coordinator for Personnel Concepts, and I'm joined by my co-moderator, Karen Jonas, who serves as our Regulatory Monitoring Manager.
Hi, everyone. Thank you for joining us. Our guest speaker today is Wayne Weissong, an attorney who is licensed in multiple states. Since 2000, Wayne has been a member of and counsel to the Atlanta-based labor law firm of Matthews & Green, LLC. Mr. Weissong's practice primarily focuses on the compliance, tax, and financial aspects of employment law and employee benefit matters. He has written extensively on various topics for a number of publications dating back to 1981 and has been a practicing attorney for 33 years. His experience includes serving as an attorney for a U.S. government agency, as in-house counsel to businesses, and as a management consultant. Thank you, Wayne, for joining us today.
Thanks for having me. Today's topic of political affiliation discrimination in the workplace is particularly timely as it is a sensitive issue that many employers are dealing with on a day-to-day basis.
Definitely. We are looking forward to discussing it with you. Before we begin, we'd like to ask our audience about their experiences with political affiliation discrimination in their workplace. The poll is open now. We'll give everyone a couple of minutes to answer. And in the meantime, I'll discuss today's agenda. So our agenda today focuses on employer and employee rights as it pertains to political affiliation. We will begin with an overview of protected political speech and anti-retaliation laws. Then we will discuss mandatory political donations and encouraging employees to take particular political positions. We'll also explore employees' political activities, such as those that occur during lunch breaks, writing emails, and blogs. Next, we will cover preventing a politically charged workplace and what policies employers should have in place. Finally, we'll discuss when an employee can be fired for their political affiliation or activities. So it looks like we have some answers. So let me just share the poll results. So it looks like most of you are saying, sometimes you have some problems. Only a few people are saying it's a frequent problem, but, sometimes seems like a, normal kind of thing. Our webinar today should help you answer some of these pressing questions about political speech in the workplace.
And the format for today's webinar features a series of questions that Karen and I will be asking to Wayne regarding political affiliation discrimination in the workplace. Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also post questions in the chat window. Most questions will be saved for the end of today's session, but those that are relevant to subtopics being discussed will be posed where appropriate. At the end of the session, you'll have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. Now, we recognize that politics are a sensitive, divisive, and controversial topic for many Americans, and all of our presenters today, myself included, will make every effort to avoid using any insensitive language or stating any personal opinions about the subject matter. We also respectfully ask that you use similar discretion if you're given an opportunity to pose a question to our guest speaker. And with that, let's get started with today's presentation. Karen?
Wayne, a big topic in the news lately is that employers have fired employees for their political beliefs. Is it legal to fire people for their political affiliation or activities related to politics?
Well, believe it or not, Karen, in most jurisdictions, with a few exceptions, it is, at least in the private sector. In fact, it can go even farther. In such jurisdictions, it is possible to be fired for political conversations or social network posts outside of work. It sounds unfair, even un-American in a society that has long had a tradition of open political discussion, particularly in election years. We are guaranteed the right of free speech. This is mainly a rule against the government abridging our speech. People have in recent years become very sensitive about political thought, and such thoughts can have a significant effect on one's career. It is safe to say that the wise employee, without regard to the strength of his or her views, will be prudent to simply dodge the subject and limit non-business conversation to weather, sports, favorite restaurants, innocuous things, and never post political opinions on social networking websites. Hard news to deliver, but it would be dishonest to state otherwise. Consider the recent case Young v. Bailey, cited by the North Carolina Supreme Court, which held that it was not a violation of the state's political coercion law for a sheriff to fire deputies for failing to contribute to his campaign. The catch was that employees of the sheriff's department were not employees of the county, and as a result, they did not have rights to free speech or refusing to exercise such speech rights in order to contribute. Other odd cases with highly questionable conclusions illustrate that even where one appears to be a government employee, free speech rights are not necessarily guaranteed.
And are there circumstances in which political speech and activity is protected?
Well, there are a number, Leon, and I'll give you some examples. They're not exhaustive, but they're the main ones. The National Labor Relations Act prohibits employers from disallowing employee discussions of workplace conditions. So employees may discuss why they believe a certain candidate is better for them as a worker without being fired for having the discussion. On the other hand, it appears that employers can force employees as a captive audience to attend meetings and listen to one-sided political pitches on behalf of candidates. Oregon has a law prohibiting such employer conduct, as does New Jersey. While employers can prohibit wearing of most political buttons, shirts, and other campaign items, it cannot prohibit union insignia if a union is in place in the business. Some states and localities prohibit employers from firing or disciplining employees for legal activities outside of work. In such states, an employee cannot lawfully be fired as long as the activity is legal. If an employee works under a contract which says an employee can be fired for cause, the contract should be very clear on what constitutes cause. If it prohibits certain political activities, and assuming it is lawful to limit them, the contract should describe exactly what are considered prohibited political activities. Most states, but not all, require employers to let employees take time off to vote. Before an employee speaks out at work or anywhere about something the employer, customers, or co-workers might deem offensive, he or she needs to think about how little protection there is. The employer's written policy should emphasize this and urge employees to be very careful about any remarks or comments that others might find politically offensive.
Wayne, you mentioned some state laws addressing employee speech. Are there other state laws addressing political affiliation or activities that might offer additional protections?
Yes, Karen, there certainly are, and I'll go through a short list here, just by way of illustration. Some states and some counties and cities have laws prohibiting threats against employees to influence their vote. The Civil Service Reform Act of 1978 prohibits political affiliation discrimination against federal employees. Michigan law prohibits direct or indirect threats against employees for the purpose of influencing their vote, as well as any tracking of political activity. Ohio, West Virginia, Pennsylvania, and Kentucky prohibit employers from posting or handing out notices threatening to shut down or lay off workers if a particular candidate is elected. Oregon declares it illegal to threaten loss of employment to influence voting. In Washington State, it's illegal to retaliate against employees for failing to support a candidate, ballot position, or political party. California, Colorado, New York, North Dakota, and Louisiana make it illegal to retaliate against an employee for their off-duty participation in politics or political campaigns. And in Florida, it's a felony to discharge or threaten to discharge any employee for voting or not voting in any election, state, county, or municipal for any candidate or measure submitted to a vote of the people.
And Wayne, do discrimination laws come into play with a political affiliation?
Well, in a sense they may, Leon. An employee may not lawfully be retaliated against for reporting unlawful discrimination to HR. This includes all discrimination based on race, sex, religion, national origin, disability, pregnancy, age, or some other protected status. Political candidates may be Hispanic, black, or female. An employer may not limit political discussions by some employees, but may be able to limit political discussions by all. In particular, a lot of partisan politics focus on religion, and if an employer allows only certain points of view on such questions, discrimination laws could come into play. An employer will probably be better off to either allow open discussion of all points of view or completely ban political discussion. But then, how is it to define political discussion? That definition will prove elusive, and if stated in a policy, should be thought through very carefully. Also, if a training program receives funding under the Workforce Innovation and Opportunity Act, a participating employer cannot lawfully discriminate against anyone based on race, color, religion, sex, or political affiliation or belief.
How about anti-retaliation laws? Would they apply in some circumstances?
Surprisingly, Karen, political speech and activity, especially in the private sector employment, is not well protected by anti-retaliation laws. The law may protect employees in some places. Federal employees, as I mentioned, receive broad protection. Some jurisdictions that protect private employees are, and I apologize for the list, but these laws are all over the place. Colorado, North Dakota, and Utah prohibit discrimination based on lawful conduct outside of work. Montana is the only state that bars employers from firing people without good cause. Additionally, the good cause must be job-related. Failing to perform job duties satisfactorily is an example. Connecticut prohibits discrimination based on the rights guaranteed by the First Amendment, so Connecticut has basically adopted the First Amendment by law for all private employers. The state applies the same rules to private employers that are applied to public employers under the First Amendment. For private employers, the activity must not substantially interfere with the employee's job performance. New York prohibits discrimination for off-duty recreational activities such as arguing about politics at a social event. And here comes another list: California, Colorado, Guam, Louisiana, Minnesota, Missouri, Nebraska, Nevada, South Carolina, Utah, West Virginia, Seattle, Washington, Madison, Wisconsin, all prohibit employers from retaliating against employees for engaging in political activities. It's important to check with your specific state because what activities are defined as political varies between states and localities. For example, in California, courts have held that advocacy of forcible or violent conduct does not qualify as political within the terms of the statute. So an employee can be disciplined or fired in California for vocally advocating any kind of political violence. New Mexico prohibits employers from discriminating based on political opinions. So no political thought police there. Washington, D.C., Utah, Iowa, Louisiana, Puerto Rico, Virgin Islands, Broward County, Florida, and Urbana, Illinois prohibit employers from discriminating against employees based on party membership. Illinois, New York, and Washington state prohibit employers from discriminating against employees for election-related speech and political activities. Arizona, Washington, D.C., Georgia, Iowa, Minnesota, Missouri, Ohio, Oregon, and Washington prohibit employers from discriminating against employees who have signed initiatives, referendums, recalls, or candidate petitions. For example, in these states, an employer would not be able to retaliate against someone for signing petitions supporting certain initiatives such as anti-same-sex marriage or same-sex marriage. Finally, Louisiana, Massachusetts, and Oregon prohibit discrimination based on contributions to a specific campaign. Now, many standard union contracts prohibit political activity discrimination, and some employers include this type of discrimination among the categories prohibited in their company's anti-discrimination policy disseminated to employees. In Heffernan v. City of Patterson on April of 2016, the Third Circuit held that if an employer demotes an employee out of the desire to prevent that employee from engaging in political activity, the employee is entitled to challenge that unlawful action under the First Amendment and Section 1983, even if the employer's actions are based on factual mistake about the employee's behavior. So as you can see, the laws vary greatly around the country on this point.
Yeah, we could definitely see that. Looks like the states are pretty divided on some of these issues. So thanks for breaking that down for us, Wayne. Now, this may seem a little far-fetched, but does workplace political chatter overheard by others who disagree give them a grounds for a hostile environment suit?
Not likely, Leon, not likely. Other federal and state laws which have been used to prohibit hostile work environments based on sex, race, and religion, for example, do not make workplace political activity or expression completely protected. Even if political activity was included, to create a hostile work environment, the activity must be severe or pervasive. Nevertheless, employees would be wise to keep their political discussions outside of work, and it's generally fair game for employers to encourage employees to keep their political views off the job.
And Wayne, I've also heard of employers who ask employees to donate to certain political candidates or require employees to attend a political rally. Are those type of requests legal?
Well, that's a very good question, Leon. Coercing employees to donate money to a candidate is illegal under federal law. However, when an employer asks for voluntary donations to candidates or attendance at political rallies, employees may have concerns that management will consider such participation in promotion and wage decisions. Nevertheless, it is legal for an employer to make employment decisions based on an employee's political participation or lack of participation, unless the employee is in a state or locale where doing so is against the law. For example, in 2012, a coal mining company coerced their employees to attend a presidential candidate's rally by telling the employees it was mandatory when it actually was not. The employees were not paid that day because the mine was shut down for the rally. If an employer does not respect political differences among employees, it could be time for the employee to consider a career move if the difference is important enough. They cannot necessarily count on a law which appears to protect them from such attendance. Where a supervisor says attendance is mandatory, but the company's formal written announcement of the rally makes it quite clear that it really is not, employees should consider it a red flag.
Are there laws that prohibit an employer from trying to encourage employees to take a particular political position?
No federal law prevents employers from trying to convince employees to vote a certain way. Some states outlaw employer political coercion, but they are generally unclear.
And what if an employee conducts political activities away from the office, for example, like during their lunch hour?
Well, Leon, in most states, there is no law against political activity retaliation. An employee could in those states be disciplined or fired for leaving work to attend a rally or other political event, even if they are allowed to leave for lunch and do not exceed the allowable lunch period. However, employers who allow their employees to leave the premises for breaks should consider whether it is really worth the effort to discourage such political activity. First, it's not terribly good for morale. As a practical matter, such restrictions are very hard to enforce, especially with exempt employees who may have no lunch period restrictions. Employees who do not have legal protection under anti-retaliation laws should be aware that their risk is higher if the political views they support conflict with the views of the company or superiors. In general, employees should not let any kind of outside activity interfere with work, even if the company does not strictly enforce the lunch hour. A wise employee should not take advantage of this by being absent for too long, regardless of the reason. Issues of what workers can do while off duty, like attending rallies and working for political candidates, have raised questions in the past, but the internet has intensified the debate. It is generally unwise for an employee to post a photo of himself or herself on social media. It can get the employee scolded by the boss, if not fired. Workers should think twice about publicly posting any selfies, particularly if they highlight any political activity they're involved with at the time.
Wayne, what about employees who use company email as a vehicle for political discussions?
Well, email can be an efficient way to communicate, but on occasion, endless political banter can get going and become a major distraction. Workplace emails are largely unprotected under the law. The employer has usually won any cases involving use of company email, as there is no reasonable expectation of privacy there. To assure the maximum protection, employers should have a clear and lawful written email policy. At a minimum, HR should neutrally remind employees of the diversity of political views in the workplace, encouraging them to be respectful of each other and mindful of the effect their words have on others.
Now, earlier you discussed an employer solicitation of a particular political campaign, but what about when employees try to solicit to other employees?
Some companies ban any solicitation for any reason on the employer's premises. Some complain that employers enforce these policies too strictly and ban such activities as Girl Scout cookie sales. Others can complain that they are inconsistently enforced, with fundraising allowed only for certain pet causes. There is no law that prohibits private employers from fairly governing workplace solicitation, but it does behoove them to be consistent.
Wayne, how about employees that wear political buttons to promote a candidate? Can an employer prohibit this in the workplace?
A non-union employer may prohibit the wearing of political buttons and other wear under a neutral dress code policy, such as by banning all buttons, hats, etc. Union employers can limit such buttons to the appropriate union insignia, but this does not mean it must necessarily allow campaign buttons or posters promoting specific candidates or ballot initiatives unrelated to union organizing and concerted activity.
So Wayne, we discussed a lot of the do's and don'ts as it pertains to political affiliation. Could you go over some ways that employers can prevent their workplace from becoming politically charged in the first place?
Absolutely. We live in times of unusual political sensitivity and even animosity. To promote and maintain a healthy workplace environment, executives, managers, supervisors, and employees must all exercise restraint and common sense. A culture should be fostered that emphasizes that the workplace is not the best place to promote one's personal political viewpoint. Employers should not jump to fire employees, but it is fair game to counsel them that something they are saying or doing may be offending others and that they should tone it down. Stay focused on the job, not on persuading people to follow your philosophy. There's plenty of time for that outside of the workplace. Some things employers can do to prevent excessive workplace political activism include prohibit political conversation. However, some states explicitly forbid private companies from restricting free speech, so this will not work everywhere. If the employer can't outright forbid political speech, it can take action to discourage political speech, which might cause potential workplace conflicts. If nothing else, sensitivity training is always an option. Ask people to voluntarily limit political discussion, express concern that it could harm the overall workplace environment and lead to tensions among workers that can harm productivity. And of course, that means harm raises, harm bonuses, hit them in the pocketbook. Update the employee handbook. The employee handbook and code of conduct can be used to communicate the employer's expectations for employees in the workplace. It should emphasize that all employees must treat each other with dignity and respect differences in opinions. The employee handbook can also advise employees that the company's email and information systems are only for business-related purposes. However, there are limits. In 2016, the National Labor Relations Board threw out a provision in T-Mobile's employee handbook that required workers to maintain a positive work environment by communicating in a manner that is conducive to effective working relationships. Sounds pretty harmless, but the board held that the rule stifles workers' rights under Section 9 of the NLRA to engage in concerted activities. So as an employer, be sure to avoid drafting overly broad provisions and remain neutral.
Throughout this conversation, you've mentioned employer policies. Could you discuss with us which workplace policies employers should consider addressing?
Certainly, Karen. It's important for employees to have clear rules and communicate them to employees. First, though, they must know the rules applicable to the location, since these laws vary greatly by state, county, and city. With the assistance of their counsel, they should write and post clear formal policies. Employers in multiple jurisdictions may have to have multiple policies, one for each jurisdiction. Most employers think it wise to ban all forms of solicitation, including political campaigning in the workplace. Singling out political activity can be problematic in many locales. But an employer should consider having the following policies in place. 1, anti-harassment and anti-retaliation. Employees should not be harassed or retaliated against for their political views, even though they should at the same time avoid being too loud about it. Policies should make that very clear. 2, zero tolerance. Employees should be put on notice that violation of the policy could be grounds for discipline up to and including termination. 3, workplace violence. This is quite simply unacceptable conduct, even where due to political differences. 4, social media. The employer should clearly state what it expects from employees regarding its use, both in and away from work. And 5, company systems. The employer's policy should make it clear what kind of internet usage is permitted, as well as the use of its other electronic systems.
Thanks again for that, Wayne. I want to remind the audience that you can pose questions. We're just about wrapping up, so if you did have any specific questions for your state or workplace, go ahead and pose those now, and then we'll make sure to deliver those to the Wayne at the end of the session. Before that, though, Wayne, can you give us some examples of activities that could get an employee fired for their political affiliation?
Well, I'll name a few that actually happen. Hanging political cartoons on an office door cost somebody their job. Sending emails to colleagues soliciting support for a controversial cause has caused people to hit the unemployment line. Writing a blog at home stating opinions about a local campaign and posting on Facebook has caused problems for employees. More specifically, there have been a number of stories of employees who were fired for their political affiliation. I'll give you some examples. During the 2004 presidential campaign, a woman was fired from her job in Alabama because her car had a Carrie Edwards bumper sticker. Her boss was a strong George W. Bush supporter. Ironically, she was later hired by the Kerry campaign. A freelancer was not an employee, so did not have to answer to a boss about her politics, but she lost a contract because of her political beliefs. In 2011, a waitress at an Outback Steakhouse in Illinois said she was fired for wearing a brightly colored bracelet with the motto, "Don't tread on me." This is a motto used by the Tea Party. Her mother got her the bracelet at a Tea Party event. The waitress said a couple complained to the manager and she was fired. Outback said it was for other reasons, but the incident prompted protests in front of the restaurant. A woman filed a lawsuit claiming she had been fired from an Ohio military contracting company for voting for President Obama. The company said she was laid off for economic reasons, and the case was settled out of court for an undisclosed amount.
Wayne, thank you so much for discussing this very divisive topic of political affiliation in the workplace. I think many of us have encountered it over the last year, and it has ignited a firestorm of questions for employers trying to control it. Do you have any final tips or best practices for our audience?
Thanks, Karen. I do have some specific recommendations or tips for our audience today. Convene a meeting of HR, upper management, and any in-house counsel. Discuss what is the best company policy on workplace political activity. Will it be encouraged, limited, or banned entirely? Assess any past problems resulting from workplace political activity and decide on the best way to address those problems. Consult with any union representatives about any potential policy if it involves a union shop. If the union concurs with the policy, it is more likely to be found acceptable. Survey the applicable law before making a decision, using the advice of legal counsel if at all possible. Draft the policy in the clearest and most straightforward possible terms. Communicate the policy to employees through widespread written announcements and meetings. And consistently apply the policy without playing favorites.
Thank you, Wayne, for reviewing this information with us. Before we end today's session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Leon will ask the questions on behalf of our attendees.
Hello, and I want to thank all the attendees that have submitted questions. It's much appreciated. We'll go through the list that we have here. If you do have any last-minute questions, go ahead and get them in now, and we'll do our best to answer them. If not, we'll get back to you after the webinar. So I'll start off with this one, Wayne. If you have a political fanatic who continues to talk about political viewpoints, even if you ask them to stop, what can you do as an employer to rectify the situation if you do not have a policy in your handbook forbidding political discussion?
You do not have a policy?
Right. If you don't have a policy, what's the best way to go about forbidding political discussion?
Well, in that circumstance, I would say have the upper level management or a significant reporting official call him in for counseling and tell him to tone it down. Just flat tell him or her to tone it down. It's ticking some people off, and that you don't need that in the workplace. That you don't have to threaten firing him at first anyway. Just tell him you're causing us a problem and tone it down. This is not the place to be selling your political views. We're here to conduct business.
And is there any risk with just implementing a policy when you do see it becomes a problem? Can you change your handbook and in times, during elections or things like that, and when you see that there's issues coming up in the workplace?
Sure. An employer can always change its policies. it can it could change its policies anytime it likes. But it should always disseminate them. It should put the employees on notice what the change in policy is.
Sure. And then are you aware of any bills at the federal level that will address political affiliation in the workplace? If not, do you foresee that happening anytime in the future?
I'm not aware of any. The way things are going in Congress, I don't know if we could expect anything to happen in the near future.
Right.
But no, I'm not aware of anything, and it's more of a practical workplace issue and employer policy issue than it is a federal government issue. I don't think we're to that point yet.
Right. I do have a question, a pretty specific question from Claire in our audience. Based on someone's political views in their workplace, we had an employee look up someone's public criminal record. The individual felt discriminated against by the employee. What do you recommend management to do? Basically intervening between the two employees.
I believe the magic word you said was public. It's a public record.
Right. Yes.
If it's a public record, she has no right to privacy. So there's really nothing management needs to do except maybe say, hey, don't spread that around. But no, if it's a public record, unless you have a policy against discussing public records, I don't think you can do a lot except encourage that individual to not spread it around. I mean, the employer has a lot of leverage. I mean, these people want their job. And usually when the employer says, we don't want you doing this, most people will back off. So probably the best thing is just call her in and say, look, hold this down. We don't want this spread around.
All right. Sounds like pretty good advice. Now, I guess to kind of avoid situations like that, would you recommend that employers implement a policy that prohibits all political discussion and paraphernalia, or would having a policy like that be too risky? Could you see any risk with that?
Well, it depends where you are. I went through a long list of states with all different laws. So it starts with figuring out what the laws are where you are. You might have to have, if you're in more than one state, as I mentioned, you might need different policies for different locations. But generally speaking, I don't think it's a good idea to completely bar political discussion. It's kind of pie in the sky. It's great if you can do it. It'd probably be a dream world for employers, but you could at least, it's going to happen, but you can at least sort of make people pay a price for doing too much of it. I don't know if I would try to ban all political speech, because defining what's political can be very difficult.
Right.
What one person thinks is political, someone else might think is something else entirely. But no, I wouldn't say I support or advise banning all political speech, but it certainly should be reined in, and people who cause disturbances with their views should be called in and counseled. And if it gets bad enough, I guess you're going to have to implement a policy.
So, right, just kind of deal with the issues and employees as they come up. Seems like the best way to go. And within the parameters of your state law. So yeah, once again, great advice, and it seems like you're pretty thorough. You've answered all the questions that we have received, so it looks like you're pretty thorough with the information you gave. So definitely appreciate that, and the state breakdown was definitely useful, I think, to our audience today. So at this time, any unanswered questions will be forwarded to Wayne. So if you do have questions, audience, feel free to keep submitting those, and we'll get them over to him, and his responses will be sent out to all attendees in the coming days. Thank you so much to everyone who did submit questions about today's topic, and thanks to Wayne for taking the time to answer them. Karen?
This concludes today's webinar. Thank you for attending today's presentation. We hope you found this information useful in understanding political affiliation discrimination in the workplace. And thanks again to Wayne for being our guest panelist. We look forward to thank you. We look forward to continuing to work with Wayne on future presentations. And to all of our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.